Good afternoon, everybody. Thank you for coming today. We are excited to have you all here for our Lunch and Learn. Today, we're excited to have Brent Fassett, partner at Williams Sononi, Goodrich & Rosati, joining us to share his expertise on the top 10 tips for setting up your company. Brent is a corporate attorney based in Wilson & Sononi's Boulder office, where he works closely with emerging growth companies and the investors who back them, particularly in the life sciences and medical technology industries. His practice spans everything from venture capital financing, mergers and acquisitions, to IPOs, licensing, and employee compensation plans. Over his career, Brent has guided countless founders and investors through the complex legal and financial milestones that define a company's growth trajectory. In today's session, Brent will walk us through 10 essential steps for building a solid foundation, from leaving your current job and allocating founder equity to avoiding liability, negotiating your first term sheet, and preparing for a successful exit. Whether you're a founder, advisor, or investor, this talk will equip you with the insights that you need to launch efficiently and confidently, avoiding common pitfalls so that you can focus on what matters most, growing your business. Please welcome me in joining Brent Fassett.
Thank you. Happy to be here today. And as I go, I've got PowerPoints just like everybody else, but working. You're good? Okay. So as I'm going through this, nobody wants to see 45 minutes of PowerPoint slides. So please ask questions. We can pressure test some of the things I'm going to say. This is also your chance to get, I've always heard that the moon is made out of blue cheese. Is that true? We'll give you an opinion on that. So we're going to go through this. I'm going to go through this, and I was talking with one of our audience members here before the class. A lot of our goals here today is avoiding mistakes that are avoidable. It's hard to start a business, right? You have technology breakthroughs that you need to make, and you're counting on developing it. You have market dynamics, markets change, customers change, other products come in. A lot of the things that I'm going to talk about today from the legal perspective of establishing your business are avoidable mistakes. And so what we're talking about here is ways to be thoughtful when you're establishing your business, and sometimes you can put off decisions you need to make to give yourself more flexibility or not commit yourself too soon to a certain path until you do find out what the market is. A big factor is until you find out who the advisors are, both that you need and are, provide the services that you need to grow your business. Who are the advisors that are going to give you good help? So without further ado, I'll get going here. But again, please ask questions. I'm happy to discuss any of these points. Okay, so you're going to set up a business, and this is before we even get into the legal factors. But the first thing you need to do is set a good foundation, like building any house or building. Number one thing is a lot of people have day jobs, and it's crucial when you start your enterprise that there is a clear distinction between what you're taking a paycheck for potentially at a current employer and what the new enterprise is going to be. I recently had an example with a founder, and we'd gone through all the steps and we were about to file it, and then he said, oh, by the way, I haven't told my employer I'm working on this. And he was starting a new AI kind of software company, and he was working on a company and doing AI for that software company. So, there was a little bit of a record scratch there. So it's important to understand, and a lot of times you can kind of moonlight, but you need to be very careful to understand that everything, the default position, if you have a day job, is everything you work on is owned by that employer, whether it's a university, a corporation, something else, unless they are very distinct projects. And by that, I mean, if you're working at Starbucks and you're starting a biotech company, you're probably okay. But if you're in a software company and you're starting another software company, you need to be very careful and understand what the distinction is between those two. So have a sense there, and not just for yourself, but if it's your friend or a colleague or a software engineer or anything else that's helping you, same facts apply, right? You need to understand that there are issues and draw a clear line there. Or, one thing that we see a lot is, I'm taking one employee from another company, and then I take a second one from there because they were buddies, and then, they bring her friend along, and then next thing you know, you've hired 6 people from the same company. So you need to be aware of that and be sort of sensitive to that as an issue. The next thing you need to understand is your relationship among your founders. It's one thing to kind of, you're at Friday afternoon, everybody's having beers, and you have a great idea on the back of the proverbial napkin. But all founders are not equal, and all contributions are not equal. And so you have to have understanding. A lot of times when we get founders come in, they'll kind of say, well, there's 3 of us, so we're each going to get a third of the founder's equity. That may or may not be the right distribution. And people can get, it can cause problems down the line and friction between founders if there's a sort of disconnect between who's got what equity and who's making what contribution. And don't just assume that because you all kind of had a good idea or, were friends on your ultimate Frisbee team, that you should all be equal contributors. Get an understanding there, get an understanding of what the role is going forward. And it's not always the case that, the person that puts in the most hours of work is doing the most contribution. If somebody is the inventor on the intellectual property, but maybe isn't doing the day-to-day work, that may be as valuable as the person that's putting in 80 hours, doing spreadsheets. Or if a person has, the key relationship with an investor or a potential customer, again, that can be as valuable as the hours put in. But you need to be frank with each other and honest of what the contribution is going in and then what the long-term expectation is of your roles going forward. You need to have a business model. This is very important. There's a distinguishing factor between I've got a good idea or a technological innovation and I've got something that is going to be a business. Now, certainly at Innosphere, that is going to give you a huge jump ahead because I know you're getting lots of coaching on that, so I won't belabor that too much, but, building the mousetrap is not a business, right? You have to understand, are people still buying mousetraps? Are mousetraps an issue anymore? Who's my customer for a mousetrap? How much can I charge for a mousetrap? And then, the other thing is sort of building the rest of the team. Obviously, you can't do this all at the beginning, and, a lot of times cash in particular is limited, but have a roadmap, right? Understand, we know at this stage we're going to have to add this capability. We may need to set aside some equity for that capability. Hey, we can do this through a consultant, or hey, this is going to be a core function. We're going to need to have somebody that's around all the time and get access to them. So those are the things to sort of lay out on paper when you're writing your business plan. Can't be a lawyer's presentation without talking about the downside. Limiting the liability. You absolutely, positively need a legal entity to start a business. And the sooner you do it, the better off you are. If you have a properly capitalized, either LLC or corporation, that can prevent access and liability to your personal assets. And that's a huge factor. It's one of the things that makes corporations successful. And it helps when you have that conversation with your significant other that you're not going to lose the house and the car if your new AI startup doesn't play out. So you need to form an entity as soon as possible. And that entity is the one that can sign contracts like non-disclosure agreements and consulting agreements, and can own patents, and can take license agreements if you're getting an agreement, whether it's from a university or somebody else. And, part and parcel is don't intermingle your personal and corporate assets. This is one of those that sometimes you think, hey, this should go up without saying, but I can't tell you how many times, you know, we get I used the company card and I bought, you know, whatever, my Xbox, or, you know, I get an email from, you know, at otterbox.com and like, hey, I'm thinking about starting a new company, or it's CSU or CU Anschutz, and I'm getting emails from, you know, a current employer. You need to make a clear distinction between the business entity and personal matters, both from a liability perspective, also from intellectual property ownership. There's branding aspects to it, but be clear of what's the business is and what's personal. And part of this is also, if you are investing personal assets in the company, track what you're putting in there, and probably put some sort of note on the books or something. You don't want to spend a year, 2 years, 3 years bootstrapping a company, and then get to the end and you get investors and you're like, well, I put in, you know, $250,000 or $100,000, or, you know, my dad has given me this much money. Track that. That needs to be tracked so you can get credit for it in the cap table of the company. You don't want to get to the end and say, well, I spent $250,000, and the investors, you know, say, where are the receipts, and you don't have them.
Can you elaborate a little bit on the perk versus LLC investors?
Yeah, and I will tell you kind of, you know, in the world we live in, you know, the determining factor tends to be, in order to take institutional venture capital money, you have to be a corporation. Venture capitalists, because of the structure and tax nature of their agreements, sometimes because they've got ERISA investors, they have to invest in corporations. So a lot of times, if that's your end goal of getting institutional money, that's where you're going to end up. On the flip side of that, I'll come back to you in a second. On the flip side of that, if you're going to get friends and family money, a lot of times those individual investors like an LLC structure, because you can get pass-through on losses, and they can use that pass-through loss to offset other gains that they got somewhere else. So sometimes, you know, the LLC can be, for individual investors, a more attractive vehicle. If it's going to be institutional dollars, it has to be a corporation eventually. So most of what we start these days starts as corporations. It avoids a step of having to do a reincorp down the line. A reincorp is not, it's not brain surgery. It can be done in conjunction with your first institutional financing, but it tends to be a little bit better for a corporation long-term. And then you get into, if you're going to grant stock options to more than 5 or 10 people, it's a lot easier to grant equity incentives to employees if you're a corporation than an LLC. So the short answer is there's no one right answer. It kind of depends on where your destination is, and, you know, how you envision the business developing and where your investors go.
Just quickly, can you talk a little bit about C Corp versus S Corp for startups that are potentially looking at?
Yeah, I mean, and that's, you know, part and parcel. C Corp versus S Corp is almost entirely tax-driven. And for those of you that aren't familiar with it, C Corp is what most of us are familiar with. You know, Fortune 500 companies are C Corps. S Corps essentially are corporations that somewhat get treated like LLCs. There are some restrictions as far as you can only have one class of stock, and there need to be individual investors versus institutional investors. So you can start as an S Corp and get some of the benefits of the pass-through treatment like an LLC, and then you can file, it's just a filing to go from an S Corp to a C Corp. Again, when you take institutional money and you sell preferred stock, which we're going to talk about a little bit down the road here, as soon as you have preferred stock, you can't be an S Corp anymore, because it's 2 classes of stock now.
Can you talk a little bit about the qualified small business?
Yes. So qualified small business stock, what we call QSBS, It's a particular treatment of equity in qualified small businesses. If you jump through all the hoops to get QSBS treatment, you can have essentially a 50% reduction in your effective tax rate on your stock when you get liquid. That's the top line. My tax colleagues would tell me there's a lot of ifs and buts on that. There's limits of how many dollars you can take in, which was just changed in the recent legislation. That threshold was gone up to 75 million. It used to be you had to hold your stock for 5 years. Now there's gradations at 3, 4, and 5 years. It is, you know, if you can take something away from this talk, QSBS can be very important. If you talk to any smart investors, they're going to pay attention to it. And so you should talk to your attorney about QSBS matters. They can be very significant, and there are easy ways to trip up your stock status on QSBS. For example, if you have one founder, they own all the equity. If you buy stock from that founder, that stock is not QSBS eligible. You can only get stock from the company to be QSBS eligible. But if you talk to a lawyer like me, we'll tell you, instead of buying that stock from the founder, we're just going to have the founder give it back to the company, and then you can buy it from the company. And then you both bought it from the company. You just can't do a person-to-person transaction from QSBS. So it's a great question. Pay attention to QSBS. I'm not a tax lawyer, and there are 101 hoops to jump through to get QSBS, but you do want to pay attention to it. Any other questions before we get? Okay. Next thing, we're going to get to is keep it simple. Especially in a startup and you're having expensive lawyer time, this is not the time to have an atomic wristwatch, right? We will tell you, if you talk to a startup lawyer like myself, we've got a pretty well-trodden path. Wilson Sonsini, we have our own platform we call Neuron. So if you come to us for an incorporation, you're going to get just a narrative questionnaire of who are your founders, who gets what equity, and then that produces literally probably 50 to 75 pages of paper of kind of how to do it. But again, don't try to get fancy on if-then statements and, if Jane stays with the company for 3 years, she'll get this much more equity. And if Bill quits after 2 years, you don't need to make it that complex. So here, we're going to give everybody common stock as founders. And this is, we're going to talk about investors in a little bit. As founders, everybody gets common stock. And I'll talk about the delta between common and preferred in a second. Here, and when we do a startup, we have you buy your shares. And at incorporation, you can buy them for literally the par value, which can be 1,000th of a penny for your stock. But you're going to buy it, which has the advantage of, A, your holding period starts, both for capital gains treatment, QSBS we talked about. You can vote the shares as opposed to options. How many of you have had options before? So those of you that have had options, right, they sound great, but you don't actually own anything. When we do founder stock, you own the founder stock. We have you buy it, your holding period starts, there's no further exercise price. We can put vesting on it, and we do put vesting on it, but that's kind of the way we talk about it. So you're seeing here, we've got 3 founders. They've decided that they're each going to be equal. You're each going to get 2 million shares. Obviously, that gets you a third, and your value is $2,000. Again, that depends on, this is at 0.001. These days, we have 4 zeros in front of the ones. So your 2,000 becomes 200. People like that even better. But as you can see here, everybody's got a third. It would take 2 out of the 3 to get to a majority when we're talking about significant corporate actions, forming the board, that kind of thing. So that's a pretty simple cap table, right? We each got a third, easy to understand, and there's not a lot of complexity. We would put a 4-year vest on this in almost all circumstances for a variety of reasons, one of which, if one of your 3 decides after a year they want to do something else, it's not fair for them to leave with the same equity as the two people that stay and keep working on it. That's the main reason we do the vesting. The other one is your investors, more often than not, will require you to put vesting on it, even if you haven't. And it's always better to negotiate with yourself. So put the vesting on when you form the company, have it be a 4-year vest. When the investor asks you, you'll say, yep, I've got it, check. You'll have better terms. You also look like you know what you're doing because you've anticipated their first question and you've responded in a positive way. And as you go on and grow the company, it's very powerful if the CEO can, talk to somebody that's coming in and trying to negotiate. Look, I had 4-year vesting. Everybody in the company has always had 4-year vesting. You, new employee, are getting 4-year vesting too. We don't cut off one-off deals. Okay, this is a huge, this is probably one of the biggest areas that gets people in trouble. Have everything in writing, right? And a law firm will help you do this, but, it can be very problematic if, again, you're doing the proverbial, sitting around and having beers or coffee or whatever, and we said we're going to be equal partners. And it's 5 years later and somebody has 80% of the stock and somebody has 20, and you sell the company and the 20% says, hey, you said we were equal partners. Mark Zuckerberg actually had a significant case like this that took him years to litigate with some of his Harvard classmates on, we all sat around the dorm and you said we were going to be equal and it was my idea, and it literally cost him like 5 years of litigation, and the stakes were half his shares of Facebook. So make sure you get it in writing. Stock allocation is a huge one, obviously. We encourage people that when you talk about stock allocation, talk about a number of shares and not a percentage. And it's fine if, you're originally talking about like, hey, we're each getting a third, but when you put it in writing, don't say you get a third, say you get 2 million shares out of 6 million, right? Don't put, and it's fine even, we see people go so far as to say, you're getting 2 million shares, which as of this date is approximately a third of the equity. But talk about raw share numbers, not percentages.
What's the thought behind that? Is it to avoid future problems or?
Both.
Okay.
The biggest one is the future problem, right? Because you don't want the expectation of like, hey, you'll always be a third. Especially, it could be a founding investor or employee. And, I thought we were equal. The classic is we're going to be partners in this. And partners has a legal meaning, right? But it's also, those of you that have gone through it before, we kind of get into like a third of what? Is it outstanding, fully diluted? I talked to you today and you said I was going to get a third, but then you did a license agreement with the University of Colorado and you gave them 10%. Did that dilute both of us or just you? There's 100 ways that this can kind of could go that way. We talked about vesting before, so that needs to be in writing and people have to understand what it means to vest or have a repurchase right if you bought the stock. And then the transfer of IP, this is another very significant factor, and it's a way that you can really, cause a problem in the founding of your company. Part of our documents and most law firms' documents of when I give you the stock, what you're going to give me is a check for whatever the purchase price is, but also your IP related to whatever our entity is going to be. And that's a huge factor. I've had several negative occurrences. You either get to the sale of the company or you're going public and somebody says, well, hey, Joe, CEO or founder, they never assigned their IP to the company. And we've been taking investor dollars, we've been growing the company, and it turned out they never assigned the IP. This is not an IP talk, but you should all know that inventorship of intellectual property is defined by statute, right? That is your role in creating the IP. And there's no way to change who the inventor of a piece of IP is, right? It's defined by the contribution to the IP. Ownership of IP and inventorship are two different concepts, right? Just because you're an inventor doesn't mean you're an owner, and vice versa, you don't have to be an inventor to be an owner. If you're working at Hewlett Packard or Meta or any of these other companies, and you have a great idea, your employer owns the IP, even if you're the inventor, right? So you need to make sure that when we're starting a company, that the entity that you're starting owns the IP of that enterprise. And the inventor go ahead.
That's for existing IP, right? So starting with no IP, do you set up a similar employment agreement assigning
Yes.
protocol?
Yeah.
Okay, how does that work if you have two jobs?
Well, now we're getting the rubber meeting the road. That's the thing, right, is you can only assign what you already own. And that's one of the things, if you have two jobs and you've already assigned that IP, you can't contribute it to the company. And one of the areas that people get in trouble of is, I'm working at, name your company Alphabet, right? And I have some, idea of an AI search engine, right? And your current employer might be interested, and you go off and, hey, I'm quitting, well, great, farewell. And then a year later, hey, I got a $25 million Series A. And they're like, hey, he was, head of R&D for our AI function. Didn't we own that? That's a big factor. And that's why you need to be very careful in drawing that distinction of, I left on October 15th. Here's my notes of when, we met and we started coming up with the idea, we started writing code, that kind of thing. Or, hey, I was working on AI for you, and now I've got a great idea of, making coffee or something. Go ahead.
Yeah, sorry, I meant this is the incorporation, you're assigning the IP, but you also have an employment agreement for this entity with a similar promise. Many startups will file provisional patents that aren't granted, right, in the early stages.
Yeah. So
similar promise to assign to the entity.
Yeah, and that's what we're doing, right, is we're trying to, square the circle. But the idea is we're going to put a stake in the sand. We're incorporating October 15, 2025. I, as the founder, assign everything that I own to our widget company, to the widget company. And then everything that I do on behalf of the widget company hereafter is owned by the company. So it's the same kind of, the agreements that we would draft in that circumstance are the same thing that, Google or anybody else would have. But, you want both parts of that Venn diagram, right? Everything that was in existence before we incorporated, I give to the company, and everything that's created after incorporation is owned by the company.
What about a service-based business? So you're going from a big company and you're starting a service.
There, it depends on whether or not there's IP available. Sometimes it can be as simple as, is there a non-compete at your current entity? A lot of service-based businesses, if the state law allows, will have non-competes, and then you'll have to contribute there. So, there may not be like what we think of in the tech or life sciences world of a new chemical entity that you're taking with you. But there can be trade secrets and, hey, I know the McKinsey model of, establishing market share or something. So you have to be careful that you don't take that trade secret that's owned by your current employer to a future employer.
By trade secrets, you also mean process, correct?
It can be, yeah. Trade, again, not an IP talk, trade secrets, kind of like USPS. We could talk about it for a long time, but be aware and talk to an attorney that is helping you on IP and incorporation, making sure there's a clear distinction between the two things. Any other? But make sure you own the IP. That could also be, if any of you are have an affiliation with an academic environment, whether it's CU, CSU, Mines, any of the other schools, a lot of times that university owns the IP regardless of your position. And so you're going to have to take a license from the university for that IP. And you need to understand, even if you kind of contribute what's left that you own, but you may not own what you think you own. So you may need a license agreement from the university, and you'll need to understand, even if you get the license agreement from the university, if you continue to work at the university and the startup, and you create IP, you have to go back to the university again to license improvements or incremental changes to your IP that may have existed before. All right, so this is where we talk about sort of all the people that are affiliated with a startup. And there's lots of different things, and this one, you know, I think is useful because a lot of people hear different verbiages and they have a sense of what those kind of titles mean. And I will tell you that titles don't mean anything unless there's a legal framework behind it. This is coming from a lawyer, you know. So for example, the word founder or founder stock has no legal meaning, right? When you look at a share of common stock owned by two people, one is a founder's share and the other's not, they have the same economic value. It might be nice to call yourself a founder, it has no legal meaning. So when we talk about stockholders or shareholders, right, you have investors. These are people who tend to give you capital to use in developing your business, and that tends to be their role. Sometimes they can also give you advice and make connections for you, but they're writing checks when we think about investors in this role. You have employees who can also get equity, but they work for the company, right? They're going to put in sweat equity on the company. And then and there can be founders. On the far end, you have optionees and employees, right? Most people, and those of you that raised your hand that got options, came in after the founding of a company. You can get options to the employees to give them a chance to participate in the equity. It's tax advantage because there's no tax on the grant of an option. But again, an optionee, right, is not a stockholder. On our buckets here, I think my other black cloud there is probably true who that black cloud is.
And as advisors for startup companies or any company, how do advisory shares play into that picture?
It depends. Again, and it's a great distinction, right? Is a lot of it comes down to the percentage. If you're coming in at the beginning, you may have a lower percentage than other founders. Hey, you're an expert in my market. I really want to make sure you've helped me and been an advisor. I want to make sure you have some reward for that. Generally, advisors are going to get options because the key factor there is options are not taxable on grant. Stock, you can't. People are like, oh, I'll give you a percentage. Even if it's 1% in a small entity, if you give the actual share of stock, it's a taxable event, right? You owe the IRS. The IRS considers that you've been given wages, but you've been given this kind of wage that you can't deposit at your bank, you can't sell on a stock exchange, but it has value and you need to pay tax on it. So you can't, when people talk about I'm going to give them shares, all you're doing is giving them tax liability, right? So you can't give somebody shares. You can grant them an option, right, the right to buy stock, or they can buy the stock up front, paying the fair market value at the time they buy the stock. Those are your two pathways. You can't give somebody stock in an enterprise without incurring a tax liability. And I will tell you that it's true that, the IRS is not generally going around saying, hey, I saw you got, 1,000 shares in Acme Widget Co. for doing consulting work. But the investors will track every share and how that share was acquired. And it will be a problem for financings if you have not properly documented kind of chain of title to your stock, okay? Because if you don't, we all know how the IRS works, right? You incur a tax liability. You may not have known you incurred a tax liability, But now, you know, penalties and interest start accruing from that time. Nobody wants their investor dollars to go out the door to the IRS, right? So anytime you're doing institutional investor due diligence, they're gonna track every single share in your company, how it got, where it got, and is it compliant with tax law, right? This is very important, and you need to have paperwork to document how it got there. Okay, so then we've got stockholders, optionees. Now you have a board of directors. The board of yeah.
Can you just quickly describe what a friends and family round is and how it fits into that structure?
Yeah, well, I'll get there. I think that'll be here in a second, but
Okay.
we'll get there. So you have, you know, your board of directors, right? And again, the board of directors are representatives of the shareholders who are entitled of sort of being responsible for the business. They're the governing entity. They hire and fire the CEO and all the executives. They make business decisions. They can handle the budget, things like that. They tend to be, you know, the more experienced people. Oftentimes, an investor will require a board seat. It's important to realize your board of directors is different than your board of advisors, okay? Board of directors you live with kind of forever. Once you're on the board, essentially in most companies, the only way you can remove somebody is if they quit or for cause, right? They commit a crime. So it's important, especially in the early stage of your business entity development, just because somebody is giving you advice, you don't necessarily have to put them on your board of directors. You can put them on your board of advisors, and that has, again, no legal meaning, right? Board of directors has a legal meaning. They have fiduciary duties to the stockholders. They have to put the company, the other stockholders' interests in front of their own as a board of directors. Board of advisors, totally different. They can come and go. There's no legal meaning. So just be careful when you're starting out of everybody that kind of helps you and is useful in your development doesn't need to be on your board of directors. You can be on my advisory board, whole different concept, right? Different legal meaning. And, you know, an advisor might get more stock than you give to your board of directors if they're particularly valuable. Two different concepts, right? And be careful because it can be, you know, at the lowest form, it can cause some hard feelings of, you know, I put 5 people on my board of directors, and then the investors came in, and now I've got to go tell my 4 friends that they're not on the board anymore, right? That can cause a lot of hurt feelings of, well, I was so important, and I was there when we were originally having coffee. Board of directors limited has a legal meaning. Don't clutter it up too much. Be very thoughtful on who's on your board of directors versus who's an advisor.
And that board of directors, if they're being paid in some fashion via stock, should that be, again, as options rather than direct stock?
Generally, again, just for the tax consequences. Now, some board of directors have been financially successful and they want to buy it, even after we get past, the first version. But generally, nobody wants the tax bill in illiquid stock, and it can be more challenging, to put the money in.
So we're a single founder, agile, small company. We have a board of advisors, just a set of advisors that we follow. But when do you think the right time to get a board of directors? When are the
So legally, in a corporation, you have to have a director. Or if it's an LLC, maybe they're a manager, it can be a title, but there has to be one of these at a corporation at least. Your board of directors, it's going to depend on kind of your your state of development. When you get investors, outside institutional investors, you'll have a board because most of them will require at least one board seat, and put a fine point on it. If it was my company, I would want at least one of my co-founders before I put an investor on. So at least for some period of time, I have control of the board before the investors take it. Most companies that go public, 70 or 80% of the directors are investor directors, right? And you need to be careful because an investor has a different mindset and goal than a founder may. a founder might say, hey, I'm here to change the world, right? And I'm gonna do whatever it takes to change the world. An investor says, I'm here to get a return, right? And that may not be compatible with your vision as a founder, right? They may say, hey, if I can double my money, I'm taking it. And you're gonna get absorbed into whatever, behemoth wants to buy you. Good luck changing the world inside, 70,000 other employees. It depends.
So, just real quick, so basically a board of directors, that's really a function of when you get investment, there's other people that have skin in the game and are wanting to help dictate that, but typically don't do that until you have investment.
Yeah, well, but it's also, if you have a really great advisor that, every time you talk to them, they add value, and you want to sort of both reward them, but also take advantage of their governance expertise, maybe they know something about your market, there can be different factors that can justify them being on the board, but you want to make sure you understand that, and you both have an understanding of what you're asking of them, and, hey, I'm expecting you to be a long-term 5-10-year contributor. You're not helping design my website, right? You're the kind of person, and it can be a way for you to attract an advisor, right? Of like, hey, I'd love to have you join my board of directors. And when people hear you're on my board of directors, that's going to be a ton of value, right? So it'll depend on the nature of the relationship and the prestige. Okay, so then we talk about, you can have founders, VPs, these are officers, right? They're employees of the company, they have the right to bind the corporation, but they don't have fiduciary duties. Employees do not have fiduciary duties to other stockholders. You should all be aware. When I talk about fiduciary duties, by the way, board of directors, when they have a fiduciary duty to the stockholders, that means if they breach it, the board of directors can lose their house. Right? Breaching a fiduciary duty is essentially the one way to what we call pierce the corporate veil. You lose the protection of the corporation. So it means something to be a board of director, and they have to put the corporation's interests before their own. Employees do not have fiduciary duties to stockholders. And this goes back to the question of like, what if I have a day job and I want to start another one? Absent the contractual restriction, you can quit and go start another company and nobody can come after you, right? Board of directors is different. If you have a fiduciary relationship with the company, that comes before your own personal role. Okay, we're going to go through the basics. We've talked a lot about this. You can have your authorized capital stock. This is your checkbook. Right? Authorized capital stock is what you file with the state of Delaware or wherever, Nevada or Texas. That's your total checkbook of capital that's available, authorized. It must exist before it's issued, and the stockholders have to approve it. Again, these sound like small legal details, but I can tell you one of the ways that a lot of companies get in trouble is either at founding or kind of down the road, they start taking money in or they give options out, and all of a sudden they realize they've promised 10 million shares. They're only authorized 5 million. By law, that other 5 million is void. And so it has to be filed with the state before you can either grant an option, sell it, promise it, whatever. And the worst experience I had was we got to an IPO of a company. They had done, seed round, Series A, Series B, Series C, and Series D. At their seed round, they had filed an initial amount of stock. They were so successful in their seed fundraising that they took in 2x the number of checks that they had authorized. Then they cleaned it up when they went and did their Series A, they authorized extra seed. Problem they had was the original seed, half of it was void when issued, which meant that when you took a stockholder vote for your Series A, you didn't actually have a majority of your stock approving your Series A. So now your Series A is void. And the new directors you elect were void. And you can see the cascade here. Right now, we're, literally ready to go public. And you have to go out to all your investors and let them know that all the corporate actions for the last 4 years were improperly approved. And all your financing was improperly approved. And literally, it'll date me a little bit, but this is when we had everybody at the printer, right? You had probably 10 lawyers for the company, 10 lawyers for the underwriters, all the accountants, billing while we're sitting at the printer for days. And we had to go get every single stockholder in the company to sign a piece of paper. Everyone, 100%, including the CEO's brother who was on a mission in Africa where they didn't have a fax machine, right? You have to have the securities authorized before you sell them. Authority to issue stock, all the board of directors. Even if you're the CEO, you can't grant an option on your own. It has to be a board action, it has to be in writing. If you're gonna sell the stock, same thing. We already talked about you can't give stock away, right? It has to be a board of directors action. And to the question before, even if you're the sole stockholder and you want to grant an option or put an option plan in, you still need a piece of paper signed by a board of directors, even if there's only one, that formally takes that action for the stock. And I think this is important, it's a concept, right, of ownership of shares in a corporation is not ownership of the corporation's property, right? So if you are a stockholder in a company, you own 1/100 of everything, but you don't own the cars or the computers or anything else, right? You own your share of the whole sort of bolus or pile of assets. But even if you're the sole stockholder, if it's a company car, that's the company's car, right? So if somebody has options, they have the right to buy their share of the car. Private company capital stock, this is where we're gonna get into it. So in a private company, stock is the ownership. You have a dual class structure, preferred and common, right? And the delta is a preferred stock in its most basic form is what's called a liquidation preference. It's also a dividend preference. It says, I get my money back before you, common stockholder, get any proceeds, right? That's the preference. When you hear people talk about preferred stock, you have a preferred liquidation preference if the company's sold or liquidated. They tend to get that first, and then the rest is what's for common. And it's important to realize this, one of the benefits of when you take institutional money is the preferred stock tends to be more expensive than the common stock. And in most startups, it can be, between 85 and 65% of what the preferred is, what the options are for the common, right? So there's a significant discount. So if your investors are paying $1, you can grant options between 10 and 25 cents. We're not going to talk about 409A, but that's the delta, right, for the preference. They also can have special voting rights. Hey, the preferred gets to elect its own director or two directors. Hey, you have to have the preferred's approval before you take on debt, before you enter a new business, before you do an exclusive license. You just need to understand what those rights are. We've talked about authorized shares, outstanding shares. If you think about outstanding, right, authorized is your checkbook. Outstanding is what you've done with it, right? Myself as a founder, I bought 1 million shares. Options are not outstanding shares, right? Options are the right to buy shares. So they are not outstanding. So when we talk about fully diluted, that's the difference between your outstanding and authorized. Employee shares are reserved, right? I've put a notation in there. I can't use them for something else, but they're not outstanding. And if I need a stockholder vote, they don't count towards my majority. Fully diluted tends to be your outstanding shares plus what you promised, whether it's employee options. There are other ways to promise shares, right? If you've sort of said, hey, if I've got a license agreement and you sell this much, I'm going to give you this stock in exchange. that can be part of it. So fully diluted is your outstanding plus whatever you've promised but may not have issued yet, less and your authorized is at the top, right? Fully diluted can never exceed your authorized, but your outstanding is generally less than your fully diluted.
You had mentioned earlier that the board of directors was the only one that could, approve authorizing shares of, authorizing shares of stock, I guess it is.
Well,
Or
stockholders approve the authorizing, the board approves the issuance.
issuance, that's what I'm saying, sorry, yes, issuance of stock is by the board. But giving options, that could later have rights to issue, is that the giving of the option, is that something that the CEO could do without going through the board, or does
No.
that require the board as well?
Board.
Okay.
With the delta between the authorized shares and everything that's been done with it, so fully diluted shares, does that just sit on the balance sheet?
Yeah,
Okay.
Yeah.
So if you have only issued 8 million shares and you're authorized for 10 million, the company owns the 2 million.
yeah, it's kind of dry powder. I mean, that's why we think about it as a checkbook, right? It's just sitting there, ready to be used for whatever purpose you might need to use it for.
But it has value though, on the balance sheet.
I'm not an accountant. I don't believe it has any value unissued. I mean, we get into treasury and stuff like that, but there's no value because it's not outstanding, right? It would have value when issued, but it's just kind of sitting there ready to be, it's dry powder for.
That's interesting. So then, like, let's say you issue the remaining 2 million delta, it would have a dilution effect.
That's right.
Okay.
That's right. We've talked about vesting, we talked about founder stock,
Well, that was, I hate to bring it up, but phantom stock.
phantom stock. Okay, so phantom stock, that's another one of these terms that can mean a lot of things, but I would put emphasis on the phantom part of the stock. So phantom stock tends to be, especially in companies that have like an LLC, it's a synthetic mechanism to attempt to give the benefits of equity from a profits perspective or ownership, but it doesn't have the legal meaning of stock, right? So a lot of LLCs will have kind of a profit sharing plan or some other bonus plan, or they'll assign you points or shares. That's part of a bonus scheme, but it's a contract and it's not equity, right? It's not the right to vote. It's not, actual ownership. So phantom stock refers broadly to different plans that tend to be compensatory, that are intended to kind of mimic, hey, you've got skin in the game, but for whether it's the legal structure of the company, it's an LLC and it's too hard to give out equity to 100 employees, or just, I'm a controlling founder and I'm gonna own everything and I'm gonna be the only vote, and I can make you think you're participating, but at the end of the day, I'm making all the decisions. So phantom stock can mean a lot of things as far as how it's structured, but like I said, the emphasis is it's phantom.
Run into them very close with them. Family owned.
Yeah, and it can be a phantom, but again, there should be a contract or a plan that spells out, what that phantom stock is, what the hurdles are, what the term, when you get a payout, right? We talked about founder stock. I'm sitting on your, friends and family. So we've talked about, founder management, common, what the preferred does, compensatory, all these things. I think we've hit that.
Go back. Just need a clarification here. This is a little bit different than what I'm establishing with a couple of VCs. That they recommend we all start with common stock. And then assume more significant rounds are raised, because everything now is pre-Series A. The founders and the main investors get preference stock. The employee stock and options plan will be common stock. I feel way safer in that scenario than in the scenario you have in the slide, that I will be a common stock when the investor will be a preferred stock.
Well, and I don't know the VC, so the thing is, when you get preferred stock, you gotta write the check for the fair market value when you get it, right? So it is unusual for founders to get preferred stock unless they're writing the check alongside the investor at the same price the investor's paying. Right, so when I was talking about like founder stock, and I can give it to you at 0.0001, that's common stock, right? When you're getting preferred stock with that sort of benefit, if they're paying $1 a share, you have to pay the $1 per share, right? So I agree, it's great, if you can pay it, you get the preferred, but keep in mind, if you're the CEO and you're getting an option, if your preferred investors are paying $1 a share, you might be able to offset the dilution by getting an option at 10 cents a share, right? No tax implications when it's granted, no money out of pocket that you may or may not have as a founder. But if you go public or are sold, your common stock and your preferred stock are each an equal share, right? So there are benefits of being the preferred. That's, he who has the gold makes the rules, right? But that may not fit your particular circumstances if you don't have capital to participate alongside the investors.
So I see it, if you don't have capital, you're going to fall here.
That's right.
In the case we have capital, we should fight for this.
Yeah. Again, because they can't give it to you, right? And if they gave you preferred instead of, for example, giving you a wage, you're going to get a W-2, and that W-2 is going to be higher because the preferred stock has a higher nominal per share value, which means your tax bill is even higher, and you still don't have money to pay the IRS.
That's great, thank you.
Okay, vocabulary. This is when you get your first term sheet. And I'll, go through this. So, and this goes to the kind of the friends and family round. Most friends and family rounds occur before the kind of institutional round. Overwhelmingly, those are done with some sort of convertible note or a safe note, right? You're putting money in, but it's not a priced round, and it tends not to be equity. But it's the right, and it will convert at a future round under certain terms, sometimes at a discount. What you have to be very careful with on friends and family is if you put a price on it, then the institutional investors won't necessarily respect the price you put on it, right? And so if your friends and family aren't in the business of valuing it, one of the things we see founders run into is they get money from friends and family, and they're like, oh, this is a great idea, and we've invented the better mousetrap, and it's worth $10 million. And so you sell your stock at a price that reflects $10 million. But then you go out, and you do some development, you've had some prototyping, you've had good customer feedback, and then an institutional investor comes in and they say, I'm going to give you $5 million pre-money. Now you got to go to your friends and family at Thanksgiving and let them know that, at least on paper, they've lost half their money. Right? That's why we tend to think friends and family is better in a convertible note that converts in the future at a priced round, because that prevents that uncomfortable decision. Usually it's, the fat part of the curve is it's a 20% discount. So if you give me my note now, when we get an institutional round, if the institutional investor is paying $1, your note will convert at 80 cents a share. Okay, valuation terms, pre-money, post-money. Pre-money, very simply, is how much myself as an investor are valuing what you have right now, right? The value of your company. And the way it works out is you take your pre-money valuation and you divide it by the number of shares that are usually fully diluted. And by that, I'm saying outstanding plus options that are granted, not necessarily your pool. Sometimes your pool can go to it, but take a discussion. It's your options plus outstanding. You've granted those options plus outstanding shares. So in our other example, if you remember, we had our founders, 3 founders, 6 million shares total. right? So if I give you a pre-money valuation of $12 million, the price per share is $2 a share, right? That's how we do it. And then I'm going to give you, again, for, sake of the argument, right? I'm going to give you another $12 million, right, at $2 a share. So I'm going to get 6 million shares. Now, when we're talking, so that's, your pre-money was 12, your post-money is 24, right? Which is your pre-money valuation plus how many dollars you got, right? So in my example, 12 is your pre, 24 is your post. Now, keep in mind that what we've done there is I now have 6 million and you three founders collectively have 6 million. I bought half your company, right? And this is important for all founders to realize. Pre-money, makes a big difference. Because we can take the same example, right? If instead of 12 million pre, I gave you a 6 million pre, right? Now I'm paying you $1 per share. And if I give you the same 12 million, I now have 12 million shares, and you three founders have 6 million. I bought 2/3 of your company, right? This is dilution, 101 kind of thing. Conversely, I'll get to you in 1 second, if I give you a $24 million pre, right? Now it's $4 a share. I give you the same 12 million. I get 3 million shares. You three founders still have 6. You own 2/3 of the company. I only own 1/3 of the company. So that pre-money valuation has a huge impact on what your outcome is.
Pre-money, do you use vested and unvested options?
Yes. Generally, there's a little bit of art to it. We're going to talk about option reserve. A lot of times, investors will make you put a certain amount of options in your pre-money to say, hey, I know that, we're going to hire 20 employees over the next 2 years. You're going to have to put enough in the option pool in the pre-money, right? So I'm making you as founders take the dilution. Because if, again, in our example with 6 million, right, if I make you put 2 million in the option pool in the pre, instead of dividing your 12 million by 6, now we're dividing by 8. Per share is lower. Myself as an investor, I get more percentage, right, because I'm paying a lower percentage, or lower price per share. We've talked about liquidation preference. Anti-dilution, this is really important. First of all, I will say founders don't get anti-dilution. We can have all different schemes of things and ways to do it. Founders don't get anti-dilution protection. Your only protection is build value in your company and charge a higher price. Anti-dilution protection is the investors saying, if after I've given you investment dollars, if you sell shares in the future at a lower price than I paid, I'm going to get a top-up.
And this can be in a SAFE agreement, for example.
SAFE is a different beast. So the SAFE, there's 3 different kinds of SAFE. There's a SAFE with a discount, which is what we talked about. I convert at, 20 or 80% of the price to the investors. There is what's known as, and this is, you need to be careful of it, a SAFE with a cap. And I think this is what you're talking about. So the SAFE with a cap says that when I convert, under no circumstances is my value going to be higher than $6 million, right? And that says, if my SAFE is converting, even if your future investors pay 12 million, 20 million, 100 million, my SAFE is converting at no more than 6 million. And that's the cap, right? And you have to be careful as founders, especially the way SAFEs work today. Once you set that cap, that comes out of your share when investors come in. So essentially, the worst part is when I have founders come to me and they're like, hey, I sold 6 million SAFE, with a 6 million cap and I'm getting 20, I've just lost all my founders' equity, essentially. I've been totally diluted down to, this is an anti-dilution, is different. This is a price-based, and it says, in the future, if I, as an investor, pay you $1 a share, in the future, if you pay 50 cents, I get adjusted. Maybe completely, maybe partially, but essentially it's downside protection for my investment. We've talked, protective provisions are what we talked about. Hey, as a preferred stockholder, you can't take on debt unless majority approves. There's a whole list of things, hiring and firing, buying and selling the company. Those are the protective provisions. So even if you, as the common holder, have 2/3 of the stock, certain corporate actions are going to require the preferred to go along. I'm not going to belabor the registration rights. One of the most experienced VCs I've talked to said if he ever paid me $1 of billable time to talk about registration rights, he's paid $1 too much. Registration rights are your right to require the company to register your stock after it goes public. That is all, that is the exhaustive knowledge of registration rights you need. Co-sale rights, that just says that if any of your common holders want to sell their stock before the whole company is getting sold, the investors get to participate alongside. We've talked about valuations. I can belabor it, but I think that sort of gets you where you are. Focusing on what matters. When you get a term sheet, and your lawyers will help you, a lot of our job is to kind of tell you, hey, this is standard, or hey, this is not standard. Top of the factors on the term sheet is valuation. I will tell you, you generally have very little flexibility in negotiating that. You might be able to get it back and forth, but especially at early stage, there's not enough leverage or objective standards. Your valuation is going to be what it takes to get the money in. I'll also tell you, nobody ever went out of business for dilution. So especially at your early stages, you kind of got to take what you can get. You can negotiate it, maybe you can walk away, but if you have unrealistic expectations, you may never get investment. Amount invested, obviously, that's important. We've talked about the option reserve, we talked about liquidation preference, board seats, protective, founders vesting terms. Those are what you want to pay attention to, right? Everything else is kind of gravy, registration rights, other things like that. And your lawyers will help you walk through that, or they should. Understand, this is important, right? We've talked about it a little bit. Investors are in it to make money. They're not in it to change the world. They're not in it to give you a job. Investors want a return on their investment. So you have to realize when you take dollars, there needs to be a liquidity event for their investment. Overwhelmingly, that's sale of the company or an initial public offering, right? You're going to sell stocks of the company and kind of, then the baby's gone. Depending on the business, there might be a cash flow event where you can sort of, give people dividends on it. But you have to understand, with institutional investors, they're in it to make money. And so when we talk about change of control and termination, provisions, that's it. The other thing you need to, when we talk about this, just because I have the opportunity to talk to you, it's important to understand the investor's perspective. Sometimes, people are like, oh, I don't want to take VC money. They're just vultures, or they can add value, right? It's not just the dollars in, but they tend to have connections, their experience in building businesses. But you have to understand, when you talk about investors, VCs in particular expect what we call a venture-like return. And because people will come to us and they, I've got a great idea and I can double your money. A VC will not be interested in that as an outcome, right? A venture-like return for a venture capitalist. If I'm a venture capitalist, I have a pool of money, I'm going to expect that every investment I make out of that has the potential, if I'm a Series A investor, to do an 8 or 10x return. Not 2x, 8 to 10x. Because what's going to happen if I'm a Series A investor is half my investments aren't going to be worth anything. Just the nature of the game, I'm playing in early stage investments, that's how it works. A couple of them are going to be good, right? The proverbial single or double. I get a 2x, I get a 3x. 1 or 2, I hope in my portfolio is an 8 or 10x. But they have to go in because they can't pick out of those 10 investments. They're no better at picking which one of them is going to be a home run and which one of them is going to be a single. Then, they're probably better than you and I, but they can't pick it, right? So every investment they're going to go in has to have the potential of an 8 or 10x. Now, when we talk about valuation, right, this is where, again, the rubber meets the road. So if I come in and I say, I'm going to give you $12 million for half your company, I'm going to project that when I exit that company, my $12 million has the potential to be $120 million, right? So, and that, by the way, means the whole company has to sell for $240 million, ignoring all the other investment and things like that, right? So when I'm talking about, myself as a VC evaluating an opportunity, that's how I look at it, and that's the math I'm doing. People can get frustrated with VCs and they're like, oh, why are they giving me so much trouble, or why can't I get VC interest? That's the number, right? If you can have a perfectly fine business, it can be cash flowing, it can throw off 10% a year, that's not a VC investment, right? A VC investment is a venture-like return. We can't be a lawyer without ending. Duties to your shareholders are real, right? You can't, if you're a startup and you have another idea for a great business, that's the company's, not yours. Securities laws matter. This is important. When you sell stock, if you're a private company, it has to be accredited investors. You can't sell it to all your friends and family unless they're accredited. Your lawyers will help you on that. You can't do a public offering. And there's, I think most of us think about a public offering like, hey, we're on NASDAQ. It's also, if you put out the advertisement in the paper or you blast it out on your Instagram, right? The SEC has a different idea of what an offering is. If it's public, it's in newspaper, it's an advertisement. It can be me standing up here and saying, who wants to invest in my Acme Widget Co., right? If I haven't qualified you all as accredited investors, that can be a problem. And by the way, again, this is a problem where if you have a bad offering, i.e. you didn't comply with the securities laws, they can come back and get what's called rescission, which means you have to give them their money back. Hint, they never ask their money back when things are going well. Right? They're getting a venture-like return. And we talked about business risk versus legal risk, and this is what I want to leave you with. All the things we've talked about today are manageable, right? You can make these mistakes. They can if you screw up your cap table, too many people on your board, you promise a percentage versus number of shares, you haven't, qualified your investors. These are all avoidable, right? But if you have to deal with them, it's expensive, it takes brain share, and it can prevent you from getting an investment, right? If you haven't checked all these boxes when you go talk to an institutional investor, you're not getting the money. At best, you're not getting the money until you go fix it. And, again, I'll date myself, but, remember the Fram oil, right? Pay me a penny today or you can pay me $1 later. It's very expensive to go back and fix these things if you screw them up initially. It's much cheaper to do them right at the beginning than it is to try to go back and fix them. Because it's cheap and relatively efficient to do them up front. It can be a big hassle to do them up, fix them up later. Any questions?
Is the SPAC still a thing?
No. I don't know, probably, there actually are a few kind of, like, we've seen.
It's still legal, right?
Yeah, it's still legal. What happened was, kind of the heyday of SPACs, the SEC came in and sort of really clamped down on how much you could take as a promoter. And I'll tell you, like, the way I know it, we just had the new set of NVCA documents come out, and one of my associates had gone through and edited somebody's old documents up to the new standard, because we're getting a new round. SPACs are gone. They're not even in the NVCA documents anymore. I mean, they still happen, but kind of there was that heyday of SPACs. Everybody was doing it, and they were super popular. They are no longer like an end around on the IPO market.
I've had a couple of investments, actually go that route in the last 2 years.
Yeah, no, there's still a few out there, and they're happening, but
Highly inefficient, very poor way to go public.
yeah, I mean, I think the way, particularly the way the SEC has done it, a SPAC is an M&A plus an IPO, right? Versus one or the other. We as lawyers love them because we can do an IPO and an M&A. But unless you're, and God bless you, we love paying, when you pay your legal bills, but they're just, the SEC came in and, you can't promote them. It's highly regulated. The advantages kind of aren't there anymore.
So what are you seeing as the primary option then?
I wish I could say, we are seeing, there is life in the IPO market, which is a little different than the last 24 months. But it's a little bit more back to the old, if you're a private company, you should be a private company. And if you're a public company or, eligible income, you can do an IPO.
I'm seeing Reg A conversion as an interesting one.
Yeah, you're seeing some of that stuff too. There's some of the crowdfunding. We can talk about all this securities law exemptions for a long time. Any other questions? I think, there's my information. This is what we love to do. We're sort of very geeky about it. If you have any questions, I'll be around here for a little bit or to follow up. But if I can leave you with, Kyle Lefkoff at Boulder Ventures says we like to make new mistakes, not old mistakes. Don't make old mistakes, right? There are lawyers around, advisors around that can help you not make mistakes that have been made a bunch of times before.